All right, welcome back. We've got a fun surprise tonight. So, I didn't expect this yet. Basically, we're going back up to Idaho. We've got updates in Scofield versus Guillard. For those of you who are new, I'm Joe. I'm an attorney licensed to practice in Utah. We're, I think, nearing the end of at least the liability portion of this case. They still will have to go to trial to determine damages, I think, but I have a feeling summary judgment is going to be granted relatively soon. So we're almost done. But that said, let's jump to the docket. Let's take a look at where we stand. Scroll all the way to the bottom. If you recall, last time we were here, we discussed the summary judgment motion, docket 56, and the response, the opposition to the summary judgment motion from Ashley Guillard, number 57. Well, the reply brief, which, I expected we'd get one. I mean, unlike Massachusetts, you don't have to ask to do a reply brief. You can just do one in Idaho, you know, good old standardized local rules. But even aside from that, Ashley's opposition was so out there and brought up so many different arguments that a reply brief was inevitable. It was due the 14th of November. I realized my video is coming out on the 14th. It's just barely past midnight though, so in my mind it's still the 13th, which is surprisingly when we got the reply brief. I wasn't expecting it today. I was expecting it to be filed on the 14th, and then my experience following this case has been the docket tends to have about a 1 day lag, or at least it often does. So frankly, I didn't expect to see anything until the 15th. So 2 days early, I'm happy. But there's more. We also have, and I'm going to go out of order here and do this first. We have the judge got in on this. Well, the magistrate. So docket 59 was also put on the record today. The memorandum decision and order regarding defendant's motion to set aside and motion to dismiss, which on the docket it says, based on the foregoing, it is hereby ordered that defendant Ashley Guillard's motion to set aside and motion to dismiss, docket 50, is denied. So we went over all that litigation a couple videos ago. So if you recall, she wanted Professor Scofield's case dismissed because reasons, but she also wanted her counterclaims reinstated, even though the court didn't have jurisdiction according to her. But yeah, so it was bad. It was really bad. And clearly, U.S. Magistrate Judge Raymond E. Patrico Jr. agrees. And so, yeah. So even though this is technically on the docket after the reply brief, I think it's important to knock this one out first because, well, Ashley brought it up a lot in her opposition in number 57. So in a way, she's right. that, there's no reason to even consider summary judgment if it's going to be dismissed anyway. Let's do things in order. So let's finish this off and then get to the summary judgment. So going to the document, it's 24 pages. I was not expecting a 24-page decision from the judge. It may be a little excessive, but I understand why he went overboard here. It's because Guillard brings crazy arguments, and she's already arguing that this is illegitimate. All your decisions are void. You're biased. You're everything. So laying it out in excruciating detail why she's wrong is a good idea from the judge. So let's get into it. So we have memorandum decision and order regarding defendant's motion to set aside and motion to dismiss. Pending before the court is defendant Ashley Guillard's motion to set aside and motion to dismiss, collectively the motion. In the interest of avoiding delay, and because the court conclusively finds the decisional process would not be significantly aided by oral argument, the motion will be decided on the record and without oral argument. As discussed more fully below, the motion is denied. So basically, he's saying, yeah, the written briefs, that's all I need to make my decision. You will not convince me by having oral arguments in court. That's a waste of time. Frankly, it would just serve to make him mad. That's the only thing she could accomplish here. I do expect oral arguments for the summary judgment, not because they're needed, just because I think it might add sort of a air of, a veneer of legitimacy to Ashley Guillard, like convince her not only were you given due process, which she has been all along, but that you've been given full process. If you get what I mean, she can't argue she hasn't had her day in court. So I think the arguments on the record are sufficient for the summary judgment, but it makes sense to me that I expect they will have oral arguments for it, even if they aren't needed. But so factual and procedural background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. And that reminds me, I meant to make this point while we were on the docket. Not that I needed to be on the docket to make it, but so as I was saying, I didn't expect to see this. Well, first off, I didn't expect it to be even filed until a day later, but I didn't expect to see it for 2 days. But I kind of almost wonder if there's some symbolism, both from Professor Scofield's attorneys and from the court, because both of these were put on the docket on November 13th, which is the 1-year anniversary of the murders. So, I just kind of wonder if there's some sort of symbolic, we've got one more day, but let's do it on the anniversary itself. So either way, it's the 1-year anniversary, and I hope the students have justice soon and that Professor Scofield does as well. So, plaintiff Rebecca Scofield is a professor at the University of Idaho. She alleges that she never met the students and was not involved with their murders in any way. Notwithstanding, plaintiff alleges defendant Ashley Guillard posted over 100 sensational TikTok videos falsely claiming that she had an inappropriate romantic affair with one of the victims, and then ordered the murders to prevent the affair from coming to light. In turn, plaintiff initiated this action on December 21st, 2022, asserting 2 defamation claims against defendant. One is premised upon false statements regarding plaintiff's involvement with the murders themselves. The other is premised upon false statements regarding plaintiff's romantic relationship with one of the murdered students. Defendant, representing herself, did not immediately respond to plaintiff's complaint by the January 17, 2023 deadline. See Federal Rule of Civil Procedure 12A1A, which says a defendant must serve an answer within 21 days after being served with the summons and complaint. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default on January 19, 2023. A clerk's entry of default was then entered and mailed to defendant on January 27, 2023. On February 16, 2023, defendant moved to set aside the entry of default. Plaintiff responded the next day, opposing defendant's efforts to set aside the entry of default and filing a motion for default judgment pursuant to Rule 55B2. On April 24, 2023, the parties consented to the undersigned's jurisdiction. The parties consented as in, I was going to make the point, Guillard's arguing about the court not having jurisdiction, but this was, they agreed to have the magistrate hear the case instead of the full U.S. District Court judge. So that's what that was. Thereafter, on April 26, 2023, the court granted defendant's motion to set aside entry of default, denied plaintiff's motion for default judgment as moot, and ordered defendant to respond to plaintiff's complaint within 21 days. On May 16, 2023, defendant filed her answer, affirmative defenses, and counterclaims to complaint. Within her answer and counterclaims, defendant denied that she defamed plaintiff because the accusations made against plaintiff in defendant's TikTok videos are substantially true. Defendant maintained that she used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of the 4 University of Idaho students, and published her findings on her TikTok social media platform. Defendant also affirmatively asserted 11 counterclaims against both plaintiff and her legal counsel. On June 6, 2023, plaintiff moved to dismiss defendant's counterclaims against her. A week later, plaintiff moved to quash the summonses for her counsel, arguing that their issuance was procedurally improper. Defendant opposed each of these motions. In an August 8, 2023 memorandum decision and order, the court, 1, granted plaintiff's motion to dismiss, insofar as it dismissed defendant's counterclaims against plaintiff, and 2, plaintiff's motion to quash. So footnote 1 regarding dismissing the counterclaims against plaintiff. However, the court did not award attorney's fees to plaintiff, In this limited respect, plaintiff's motion to dismiss was denied. Now, via the pending motion, defendant requests that the August 8th, 2023 memorandum decision and order be set aside under Rules 60B 4 and 6 because 1. This court does not have subject matter jurisdiction over the action. 2. This court does not have personal jurisdiction over her. 3. Venue is improper in Idaho. 4. The court lacks judicial impartiality. And 5. The court does not have subject matter jurisdiction over the plausibility of spiritual practices. According to defendant, these same reasons similarly warrant the dismissal of plaintiff's complaint under Rules 12b1, 2, and 6. Plaintiff opposes defendant's motion in its entirety and requests the reimbursement of her attorney's fees. Legal standards. Rule 60B. Under Rule 60B, and remember, when we discussed the motion itself and the opposition to the motion, we looked at Rule 60B in the Federal Rules of Civil Procedure. Under Rule 60B, a court may relieve a party from a final judgment, order, or proceeding for the following reasons. 1. Mistake, inadvertence, surprise, or excusable neglect. 2. Newly discovered evidence that, with reasonable diligence, could not have been discovered previously. That's what Delete Laws was trying to do in his Ironton case with the atomic clock, even though it wasn't newly discovered evidence that, because, with reasonable diligence, he could have made that argument earlier. His failure to make that argument earlier was his fault. Not that it was a good argument anyway. But, so, 3. Fraud, misrepresentation, or misconduct by an opposing party. 4. The judgment is void. Not just voidable, but void. Because Ashley Guillard says it's void. 5. The judgment has been satisfied, released, or discharged. Or 6. Any other reason that justifies relief. Rule 60B is an extraordinary remedy and is granted only in exceptional circumstances, and that's Carricker versus Rent-A-Center, Inc., 7th Circuit, 2005. So it's extraordinary relief, but it's not something to be taken lightly. I don't think more needs to be said. It's exceptional, not ordinary. The moving party bears the burden of proving the existence of a justification for Rule 60B relief. That's Cassidy versus Tenorio, 9th Circuit, 1988. The disposition of a Rule 60B motion is committed to the sound discretion of the district court. That's Casey versus Albertsons, 9th Circuit, 2004. So it's, as Casey versus Albertson says, it's the discretion of the court whether the reason is good or not. So even if Ashley appeals this, she's not going to win, because appeal, the standard will be abuse of discretion. So the appeals court would just look, did the district court abuse its discretion? Did they look at things not in the record? Did they apply the law wrong? She's not going to be able to, it's not a de novo appeal, so it's not looking at everything new. It would just be abuse of discretion. So, and that's a pretty difficult standard, frankly, for a appellant. So, Rule 60b-4. Under Rule 60b-4, a court may grant relief from a final judgment upon a showing that the judgment is void. A judgment is not void simply because a party believes it is erroneous or because they claim it's void. That's almost like a conclusion of law. So, but that was from United Student Aid Funds versus Espinosa, Supreme Court, 2010. Instead, Rule 60b-4 applies only in the rare instance where a judgment is premised either on a certain type of jurisdictional error or on a violation of due process that deprives a party of notice or the opportunity to be heard. That's also from Espinosa. And here, due process hasn't been violated. Ashley claims due process was violated, but it wasn't, because what's due process? What, or at least what does it boil down to? Notice and an opportunity to be heard. Clearly, she received notice because she's been served. That's notice. She received the complaint. She received the opposition to the motion at hand and an opportunity to be heard. Now, granted, the court isn't taking oral arguments on this motion. So you may say, well, the court isn't hearing her. It's only reading her. But written motions count. That is an opportunity to be heard. So, and so basically, Ashley's trying to say this is premised on jurisdictional error. Yo, court, you don't have jurisdiction over me. Therefore, this is void. But unfortunately for her, the court does have jurisdiction. So, and then see also U.S. versus Burke, 9th Circuit, 1999, which recognized that a final judgment is void for purposes of Rule 60b-4 only if the court that considered it lacked jurisdiction, either as to the subject matter of the dispute or over the parties to be bound, or acted in a manner inconsistent with due process of law. So, it's only if it lacks subject matter jurisdiction, personal jurisdiction, or there was a lack of due process. In considering allegations of a jurisdictional defect, the generally accepted standard is that relief under Rule 60b-4 should be reserved only for the exceptional case in which the court that rendered the judgment lacked even an arguable basis for jurisdiction. And that's United Student Aid Funds, once again, Supreme Court. So it's, I like that. It's, if there was even an arguable basis for jurisdiction, 60b-4 isn't going to cut it. It's not a void judgment. You can appeal. That's different than Rule 60b-4. It's not reconsideration. It's an appeal. The appeals court can say, yes, the court abused its discretion because, you know, there was an arguable basis for jurisdiction. We find that the court lacked jurisdiction, reversed and remanded, you know, with the instruction to dismiss, basically. So, next, Rule 60b-6. Rule 60b-6 is a catch-all provision that applies only when the reason for granting relief is not covered by any of the other reasons set forth in Rule 60b. That's citing United States versus Washington, 9th Circuit, 2005. The rule has been used sparingly as an equitable remedy to prevent manifest injustice and is to be utilized only where extraordinary circumstances prevented a party from taking timely action to prevent or correct an erroneous judgment. That's also quoting U.S. versus Jackson. Thus, to receive relief under Rule 60b-6, a party must establish both injury and circumstances beyond her control that prevented her from proceeding in a proper fashion. The extraordinary circumstances standard is intended to avoid a mere second bite at the apple. And that's quoting In Re Pac Far East Lines, Inc., 9th Circuit, 1989. So, injury, well, I mean, having her counterclaims dismissed, I guess that could count as injury, but circumstances beyond her control that prevented her from proceeding in a proper fashion. No, there was no force majeure. No, you know, she responded. She just responded poorly. That's on her. If you know the circumstances, she could have hired a lawyer to do a better motion to dismiss for lack of jurisdiction, or to do better counterclaims. Not that there would have been better counterclaims, but it was within her control to hire a lawyer. It was within her control to do a proper motion to dismiss before she effectively waived most of the 12B motions to dismiss. So that was within her control. Next up, Rule 12. Rule 8A2 requires only a short and plain statement of the claim showing that the pleader is entitled to relief, in order to give the defendant fair notice of what the claim is and the grounds upon which it rests. Citing Twombly. We've seen Twombly many times. We'll see it in every federal case we ever do. So, and a defendant may move to dismiss a complaint under Rule 12 for any one of several specified grounds, including 1, lack of subject matter jurisdiction. So 12B1 motion. And that's one of the only ones that isn't instantly waived if you answer before you assert it. And part of that is because, if for some reason the court loses subject matter jurisdiction, then the case needs to be dismissed because the court can't hear it. So, like, if Ashley Guillard moved to Idaho, there wouldn't be complete diversity among parties. So diversity jurisdiction would no longer exist. So the court would have to dismiss because it lost subject matter jurisdiction. Of course, it would be dismissed without prejudice and refiled in state court. But 2, lack of personal jurisdiction. 3, improper venue. 4, insufficient process. 5, insufficient service of process. Our old friend 12B6, failure to state a claim upon which relief can be granted. And 7, failure to join a party under Rule 19. So our analysis of Rule 12B1. Federal courts are courts of limited jurisdiction and are presumptively without jurisdiction over civil actions. So that's a pretty profound statement, and that comes from Kokkonen versus Guardian Life Insurance Company, Supreme Court, 1994. But that's profound. The federal courts presumptively don't have jurisdiction over civil cases unless there's something granting them jurisdiction. So they presumptively don't have jurisdiction over a defamation claim unless diversity jurisdiction applies or supplemental jurisdiction to tack it on to a federal claim, or you know, it just you've got to have jurisdiction granted by some federal law in order to hear it. Of course, you know, securities law, you know, the SEC sues in federal court, and that's civil. So those are civil actions. But once again, the court would be presumptively without jurisdiction, except, hey, that's our good friend federal question jurisdiction, because, well, it's federal securities laws. And so the federal government has, you know, Congress has said federal courts are the courts to hear to hear civil litigation on questions of federal law. So, you know, that's how you get over the presumption of no jurisdiction. Federal courts possess only that power authorized by Constitution and statute, which is not to be expanded by judicial decree. Subject matter jurisdiction is required. It cannot be forfeited or waived. So, personal jurisdiction can be waived. If I'm sued in Idaho, you know, if I were dragged in as a party to this case, I don't know why I would be, but if I were dragged in as a party to this case, I could say, nuts to you, I haven't done anything in Idaho. I haven't impacted anyone in Idaho. The Idaho courts do not have jurisdiction over me. And the claims against me might be dismissed. I mean, me not having, you know, it being a hypothetical, I can't say one way or another whether it would be, just because, you know, it is a fact specific determination. But even if I believed the court didn't have personal jurisdiction over me, I could waive it. I could say, you know what? You don't have personal jurisdiction over me, but I believe this is, in fact, the best place to litigate this. So I'm going to waive my personal jurisdiction complaint and assent to the court having jurisdiction over me for the purposes of this case and this case only. But then I can't down the line say, you know what? No, I've changed my mind. If they want to sue me, they've got to do it here in Utah. But if I ignore it, if I don't even mention personal jurisdiction, but I litigate the case in Idaho, and then down the line I say, hey, wait a second, you should have sued me in Utah. This needs to be dismissed for lack of personal jurisdiction. I've waived it. I have waived that argument by not making it in a timely fashion. But subject matter jurisdiction can't be waived. The court must have and continue to have. It must keep subject matter jurisdiction in order to hear a case. So If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. That's Federal Rule of Civil Procedure 12H3. Rule 12B1 authorizes a court to dismiss claims for lack of subject matter jurisdiction. Rule 12B1 jurisdictional attacks can be either facial or factual. And that's White versus Lee, 9th Circuit, 2000. In a facial attack, and that's not a punch to the jaw, in a facial attack, the challenger asserts that the allegations contained in a complaint are insufficient on their face to invoke federal jurisdiction. That's from Safe Air for Everyone versus Meyer, 9th Circuit, 2004. A party making a facial attack does not submit supporting evidence with a motion because the jurisdiction is challenged based solely on the pleadings. And that's Warren versus Fox Family Worldwide, 9th Circuit, 2003. A court must assume the facts alleged in the complaint to be true and construe them in the light most favorable to the non-moving party. So basically, it's taking the facts alleged in the complaint as true and looking at them favorably to Professor Scofield, because she's the non-moving party in the motion to dismiss. By contrast, in a factual account, the challenger disputes the truth of the allegations that, by themselves, would otherwise invoke federal jurisdiction. That's Safe Air for Everyone. In ruling on a party's factual account, district courts may review evidence beyond the complaint without converting the motion to dismiss into a motion for summary judgment. The movement may rely on affidavits or any other evidence properly before the court, and the party opposing the motion must then present affidavits or any other evidence necessary to satisfy its burden of establishing that the court, in fact, possesses subject matter jurisdiction. That's St. Clair versus City of Chicago, or City of Chico, 9th Circuit, 1989. So basically, it doesn't become a summary judgment. It's still a 12B1, but both sides have to do affidavits. They've got to put pleadings. They've got to put facts in. You're not just relying on the facts as they're pled in the complaint. That's for a 12B1 factual challenge. Rule 12B2. A court cannot adjudicate claims against a defendant over whom it has no jurisdiction. Rule 12B2 provides for the dismissal of claims where a court lacks personal jurisdiction over a defendant. The plaintiff bears the burden of establishing that the exercise of personal jurisdiction is proper. That's from Schwarzenegger versus Fred Martin Motor Company, 9th Circuit, 2004. And I'm assuming that's Schwarzenegger in his capacity as governor of California back in 2004. So, to establish personal jurisdiction, the plaintiff must show that the statute of the forum confers personal jurisdiction over the non-resident defendant, and that the exercise of jurisdiction conforms with the federal constitutional principles of due process. That's Lake versus Lake, 9th Circuit, 1987. Where the motion to dismiss is based on written materials, and where an evidentiary hearing has not been conducted, the plaintiff needs to establish only a prima facie showing of jurisdictional facts to withstand the motion. That's Wells Fargo versus Transportation insurance company, I assume, District of Idaho 2009, which itself cites Ballard versus Savage, Ninth Circuit, 1995. The court must take the plaintiff's uncontroverted allegations in their complaint as true and resolve factual disputes in affidavits in the plaintiff's favor. And that's once again Wells Fargo, but citing Dole Food Company versus Watts, Ninth Circuit, 2002. Absent a federal statute governing personal jurisdiction, federal courts apply the law of the state where the district court sits. And that's Yahoo versus, I'm not even going to attempt this in French, but it's the League Against Racism and Anti-Semitism, Ninth Circuit, 2006. Because Idaho's long-arm statute allows a broader application of personal jurisdiction than the Due Process Clause, the court need look only to the Due Process Clause to determine personal jurisdiction. And that's citing Hill versus Union Pacific Railroad Company, District of Idaho, 2019, which itself cites Wells Fargo again, saying, thus, under Idaho law, the jurisdictional analysis and federal due process analysis are the same. The Due Process Clause of the 14th Amendment requires that a non-resident defendant have sufficient minimum contacts with the forum state so that notions of fair play and substantial justice are not offended. And that's citing, well, that's Wells Fargo again, but citing basically the case on the subject, International Shoe Company versus Washington, a Supreme Court case from 1945. As an aside, my first year of law school, at the law school Halloween party, one of my friends dressed up as International Shoe. Under federal law, personal jurisdiction can be either general or specific, and that's citing Bristol Myers Squibb Company versus Superior Court of California, San Francisco County, Supreme Court. I mean, it's a 2017 case. I just find it interesting. It's on page 1776 where that's found. But yeah, so it can be general or specific. So in this case, it's specific. The court in Idaho does not have general jurisdiction over Ashley Guillard because she isn't a resident of Idaho. So it's got to determine whether it has specific jurisdiction, which would be for this issue only. You know, if someone was in a car accident with Ashley and for some reason decided Idaho was the place to sue her, it couldn't say, look, the court has jurisdiction over her. She's being sued in Idaho right now, so I can do it too. No, because it has the court exercising specific jurisdiction over her doesn't grant it general jurisdiction against her for any and all claims. She'd have to be an Idaho resident for that. A court may exercise general jurisdiction only when a defendant is essentially at home in the forum state. That's Ford Motor Company versus, I assume that's Montana 8th Judicial District, Supreme Court, 2021. And so that's kind of important when a defendant is essentially at home, because what happens, there's rich people out there that they've got multiple homes. where's home? The big part is, the biggest question is going to be, where is their domicile? And domicile is, it boils down to, where do you intend to return? So you may spend more time at your Hawaii beach house, but your hometown where you still own your childhood home, and that you have that listed as your official residence, and your driver's license is issued there, and you pay taxes there, that's probably your domicile. And it gets even more complicated with corporations, where, is it their headquarters? Is it where they're incorporated? Is it where they have a factory? Yeah. So general jurisdiction is properly exercised by a state when the defendant has contacts with the forum that are so continuous and systematic as to render the defendant essentially at home in the forum state. That's citing Daimler AG versus Baumann, Supreme Court 2014. What's with all the automotive cases? We've got Daimler, we've got Ford. So only a limited set of affiliations with a forum will render a defendant amenable to general jurisdiction there. That's Schaefer versus Heitner, Supreme Court, 1977. For an individual, the paradigm forum for the exercise of general jurisdiction is the individual's domicile. There's that word. That's citing Bristol-Myers Squibb. A court has specific jurisdiction over a defendant if the controversy is sufficiently related to or arose out of the defendant's contacts with the forum. And I should back up to domicile. Going back to our Hawaii beach home example, let's put the domicile, the childhood home, in Indiana, but they spend 9 months out of the year in Hawaii at the beach home. But they've taken affirmative steps to establish Indiana as the domicile. If the chances are, if they commit a tort in Hawaii, the court's going to have jurisdiction, because it may not be general jurisdiction, but the court can exercise a whole lot of specific jurisdiction in Hawaii. But even in cases where generally it would be held in state court, you're going to get to go to federal court, because for the purposes of diversity jurisdiction, establishing diversity is based on domicile. So they may own a house in Hawaii and spend a great amount of their time in the house in Hawaii, but their domicile is Indiana. So in the diversity analysis for diversity jurisdiction, domicile is what matters. So a court has specific jurisdiction over a defendant if the controversy is sufficiently related to or arose out of the defendant's contacts with the forum. That's Amaluk versus Langston, Slip, and Batbigary. That's an interesting name. 9th Circuit, 1995. In other words, specific jurisdiction depends on the quality and nature of the defendant's contacts with the forum state in relation to the cause of action. So, quality and nature of the defendant's contacts. Hawaii beach home, well, that's a whole lot of quality contact. And the nature, you're living there, just not domiciled there. The Ninth Circuit analyzes specific jurisdiction by utilizing a three-part test. 1. The non-resident defendant must purposefully direct her activities or consummate some transaction with the forum or resident thereof, or perform some act by which she purposely avails herself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of its laws. So that would be, if she were conducting business in Idaho, that would be purposefully availing herself of the privileges afforded to Idaho residents. And she's protected by Idaho corporate law, Idaho sales law, Idaho personal injury laws if she's injured conducting business in Idaho. But it's not just conducting business. As we'll see, it's effects too. 2. The claim must be one which arises out of or relates to the defendant's forum-related activities. And 3. The exercise of jurisdiction must comport with fair play and substantial justice, i.e., it must be reasonable. And that's citing Yahoo versus League Against Racism and Anti-Semitism. The plaintiff has the burden of satisfying the first two prongs. That's citing Lake. If satisfied, the burden then shifts to the defendant to demonstrate unreasonableness. That's citing Boschetto versus Hansing, 9th Circuit, 2008. So basically, if the plaintiff can establish the first two, so that the non-resident, the defendant purposely directed their activities or, availed themselves of the privilege of doing stuff with Idaho, and the claim arises out of those activities too, then there's presumptively specific jurisdiction. Presumptively, that the burden has shifted to the third prong for the defendant to show that even though the court could have jurisdiction, it would be unreasonable for the court to exercise that jurisdiction. It would be unfair for the court to exercise that jurisdiction. So, next up we have Rule 12b-6. The purpose of a motion to dismiss brought pursuant to Rule 12b-6 is to test the legal sufficiency of the complaint. That's North Star International versus Arizona Corporate Commission, 9th Circuit, 1983. Dismissal can be based on the lack of a cognizable legal theory or the absence of sufficient facts alleged under a cognizable legal theory. And that's Balistreri versus Pacifica Police Department, 9th Circuit, 1990. A plaintiff is required to allege enough facts to state a claim to relief that is plausible on its face. That's Twombly. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And that's Twombly's companion, Iqbal. And, well, it's not a companion legislation. It's 2 years behind, but they're often cited together because they're basically the controlling law. In determining whether a complaint states a claim on which relief may be granted, the court accepts as true the allegations in the complaint and construes them in the light most favorable to the plaintiff. That's citing Hishon versus King and Spalding, Supreme Court, 1984. However, the court need not assume the truth of legal conclusions cast in the form of factual allegations. Someone needs to teach delete laws that legal conclusions are not factual. The court does not have to assume your legal conclusions to be true. You saying there was no probable cause to arrest me, that's a legal conclusion. The court gets to decide that. And that was citing U.S. ex rel. Cheney versus Ringrose, 9th Circuit, 1986. While Rule 8 does not require detailed factual allegations, it demands more than an unadorned, the defendant unlawfully harmed me accusation. So it can't just say, the defendant defamed me. It's got to say, the defendant defamed me by saying, I enjoy the company of sheep, when in fact I do not enjoy the company of sheep in the slightest. So basically, it can't just be saying, yeah, here's a cause of action, they did that. You've got to have some factual allegations. So, and that's citing Iqbal again. A pleading is insufficient if it offers mere labels and conclusions or a formulaic recitation of the elements of a cause of action. That's citing Twombly. See also Iqbal, which says threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Moreover, it is inappropriate to assume that the plaintiff can prove facts that it has not alleged, or that the defendant has violated the laws in ways that have not been alleged. That's citing Associated General Contractors of California versus California State Council of Carpenters, Supreme Court, 1983. So that's our legal standard. Now the discussion. The court has subject matter jurisdiction. Federal courts have original jurisdiction over cases where complete diversity exists between the parties and the amount in controversy exceeds $75,000. 28 U.S.C. Section 1332A. That's the statute for diversity jurisdiction. Here, and remember our video from about a month ago discussing the constitutional origins of jurisdiction. The amount in controversy isn't specified in the Constitution. That's just in the statute. But suits of citizens of different states, that's in the Constitution. That's in the U.S. Constitution, Article 3, Section 2. Here, plaintiff alleges that jurisdiction is proper under 28 U.S.C. Section 1332 because there is diversity of citizenship and the amount in controversy exceeds $75,000. Defendant disagrees. She argues that, while the parties may be citizens of different states, her TikTok videos claiming that plaintiff had an affair with a student and then ordered the murder of 4 students to cover up the affair did not actually cause plaintiff to suffer any damages. According to defendant, without damages, there is no legitimate amount in controversy, and thus no diversity jurisdiction, which one, renders the court's August 8th, 2023 memorandum decision and order void under Rule 60b-4, and two, warrants the dismissal of plaintiff's defamation claims against her under Rule 12b-1. Defendant's argument is without merit. Here, defendant essentially brings a facial challenge to plaintiff's complaint that plaintiff's allegations, even when taken as true, fail to show the amount in controversy exceeds $75,000. Defendant points to the fact that plaintiff neither lost her job nor was prevented from advancing in her field. And that's docket 50-1, which says, defendant did not harm plaintiff's reputation. In fact, plaintiff's reputation increased positively as proven by news media, social media, and her GoFundMe fundraising campaign, which is still active. It's still linked at the bottom of my videos. The case still is going to need to go to trial to determine damages, so yeah. Defendant also questions the extent of plaintiff's alleged severe mental distress and, relatedly, how defendant could have even caused such injuries when it was plaintiff who killed the 4 University of Idaho students in the first instance, and nobody believed in the power of the tarot and defendant's psychic abilities anyway. In a diversity case originally filed in federal court, the sum claimed in the complaint controls if the claim is apparently made in good faith. It must appear to have a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. That's citing Maine Community Health Options versus Albertsons Companies, Inc., 9th Circuit, 2021. The legal certainty test permits a district court to dismiss the case for lack of jurisdiction only if it is obvious on the face of the complaint that the suit cannot involve the necessary amount. That's citing Geographic Expeditions versus Estate of Lotka, XREL Lotka, 9th Circuit, 2010. So that would be a case where, let's say, there's a contract for $50,000 that is breached. $50,000 must be less than $75,000. So there is no diversity jurisdiction, unless there are other damages alleged besides just the base amount of the contract. This standard makes it very difficult to secure a dismissal of a case on the ground that it does not appear to satisfy the jurisdictional amount requirement. That's Neff versus Frey, 9th Circuit, 2015. To be sure, just 3 situations meet the legal certainty standard. 1, when the terms of a contract limit the plaintiff's possible recovery. So, my example, a contract that would pay $50,000 must be less than $75,000, unless there might be a treble damages provision. Hey, that brings it up to $150,000. So, I mean, this wouldn't matter anyway, but let's say you were unlawfully dismissed from your job. And well, your employer kept back $50,000 of your income. You sue for that $50,000. It's contractually owed to you under your employment contract. Well, employment contracts, wage disputes generally are going to have a treble damages by law. So that becomes $150,000. But that wouldn't be diversity anyway, because it's going to be a federal question of employment laws. So most likely. But 2, when a specific rule of law or measure of damages limits the amount of damages recoverable. Or 3, when independent facts show that the amount of damages was claimed merely to obtain federal court jurisdiction. Defendants' arguments most closely align with the third scenario. Importantly, however, those arguments only represent challenges to what plaintiff may ultimately recover. They do not involve any objective, upfront criticism of plaintiff's claim to damages, or, for that matter, the amount of those damages. As a result, defendants' arguments represent an attempt to do what the Ninth Circuit has prohibited: smuggle in merits-based arguments into the jurisdictional inquiry. That's Green versus Harley-Davidson, Ninth Circuit 2020. See also Arias versus Residence Inn by Marriott, Ninth Circuit 2019, which says the strength of any defenses indicates the likelihood of the plaintiff prevailing. It is irrelevant to determining the amount that is at stake in the litigation. Arias's argument conflates the amount in controversy with the amount of damages ultimately recoverable. So, as I said when we discussed the motion a couple videos ago, let's say Professor Scofield wins, goes to jury trial, and the jury awards Professor Scofield $50,000. That $50,000 is once again less than $75,000. But the court doesn't then say, whoa, $50,000, case dismissed, I have lost jurisdiction because it's no longer for more than $75,000. It's allegations of $75,000 or more. That's what's important. If you ultimately end up being awarded, or heaven forbid, recovering less than $75,000, that doesn't retroactively remove jurisdiction. So, and then Geographic Expeditions said, the existence of a valid defense to a claim does not eliminate federal jurisdiction. As the Ninth Circuit has cautioned, if a district court had to evaluate every possible defense that could reduce recovery below the jurisdictional amount, the district court would essentially have to decide the merits of the case before it could determine if it had subject matter jurisdiction. That's Geographic Expeditions again. So basically, the court says, hey, if we had to determine damages before we could even determine jurisdiction, jurisdiction would never be decided until the end of the case. So by that renders basically every case either not having jurisdiction until proven, which would be at the end of the case. So it doesn't have jurisdiction because it hasn't been proven yet. So it turns it into a circular argument, and either all cases would have jurisdiction or no cases would have jurisdiction, or you'd have to prove jurisdiction first, in which case you'd have already heard the case. So what's the point in having a jurisdictional amount to filter out cases not worth the federal courts? The reason they have this jurisdictional amount is to filter out lower cases. It's you know, if you've been damaged, you deserve to be heard in court. But the federal court is saying, you know, if we're going to be paying for the court, if we're paying for the courthouse, for the judge, for the clerks, for the whatever, we only want to hear state claim cases in federal court if they're higher stakes. The low stakes cases, Have at it in state court, in small claims court. Here, defendant's TikTok videos accuse plaintiff of not only having an improper relationship with a student, but then masterminding the murder of 4 students to keep that relationship a secret. Plaintiff alleges that these videos are defamatory and that she suffered actual injuries in her life, career, and mental health as a result. Without weighing in on the merits of these claims, it is not unreasonable for plaintiff to seek damages that compensate her for these alleged injuries. Nor is it inconceivable that such damages exceed $75,000, depending on the nature and extent of those alleged injuries. That the parties dispute the facts informing these aspects of plaintiff's case are not resolved here, but instead must be determined by the trier of fact based upon the evidence. So, like I've said, we're looking for summary judgment on liability, but there needs to be a trial, probably a jury trial, because the judge might be sensible and grant her 75,000. The jury might actually award her that 2 million she's looking for. As such, the court cannot find to a legal certainty that plaintiff's claims against defendant are really for less than $75,000 and simply a procedural maneuver to falsely obtain federal jurisdiction. Defendant's motion is denied in this respect. Next, the court has personal jurisdiction over defendant. Defendant argues that the court does not have personal jurisdiction over her because she is a resident of Texas and her TikTok videos were published mostly in Texas and accessed in several states. Absent personal jurisdiction, she claims, the court's August 8th, 2023 memorandum decision and order is void under Rule 60b-4, and plaintiff's defamation claims against her must be dismissed under Rule 12b-2. Defendant's argument is without merit. To begin, personal jurisdiction is a personal defense that may be waived or forfeited. I mentioned that earlier, as opposed to subject matter jurisdiction, which may not be waived or forfeited. That's Mallory versus Norfolk Southern Railway Company, Supreme Court 2023. Even if defendant arguably preserved the defense within her answer, footnote 2, defendant does not specifically assert lack of personal jurisdiction as an affirmative defense in the answer. In the context of venue, however, she notes how she is a resident of Texas and that the publishing of TikTok videos took place in Texas. So even if she didn't, even if she arguably preserved this defense in her answer, she nonetheless forfeited it when she substantially participated in the litigation without first moving to dismiss under Rule 12b-2. That's citing Argonaut Insurance versus St. Francis Medical Center, 9th Circuit 2021, which says, an objection to personal jurisdiction, for example, has been forfeited where, after properly preserving the objection in its answer, a defendant then fully participated in litigation of the merits for over 2.5 years without actively contesting personal jurisdiction. So it's, hey, even if you brought it up as a defense in the answer, if you then fully participated in the litigation without waiting for the court to tell you, hey, you've waived it. So, indeed, before filing the at-issue motion, defendant 1 affirmatively asserted counterclaims against plaintiff and attempted to add plaintiff's counsel as parties to the action. 2 submitted briefing and made oral argument relative to the merits of those claims in response to plaintiff's motion to dismiss and motion to quash. 3 participated in the Rule 26F discovery conference, stipulated to litigation deadlines moving forward, and filed a discovery plan. And 4 pursued discovery from a third party via a subpoena issued under this court's authority. That's the Facebook subpoena that we went over a couple videos ago. So, defendant's involvement in these discrete aspects of the case reveal that she has assented to the court's authority to adjudicate and correspondingly forfeited any challenge to the court exercising personal jurisdiction over her. So the court says, hey, she's assented to our personal jurisdiction, but there's more. Regardless, the court has personal jurisdiction, specific jurisdiction over defendant. Footnote 3. Because defendant is domiciled in Texas, the court lacks general jurisdiction over her. Of course, if defendant was domiciled in Idaho instead, there would be no subject matter jurisdiction because complete diversity between the parties would not exist, in which case Professor Scofield would have had to sue in Idaho state court. So, specific jurisdiction applies when the challenged act was purposeful, when the lawsuit arises from that act, and when jurisdiction is reasonable. Each of those requirements is satisfied here. 1. Purposeful direction. Footnote 4. Purposeful direction, as opposed to purposeful availment, applies here since plaintiff's claims against defendant sound in tort, not contract. The touchstone purposeful direction requirement ensures that a defendant will not be hailed into a jurisdiction solely as a result of random, fortuitous, or attenuated contacts. That's citing Burger King versus Rudzovitz, Supreme Court, 1985. To address this concern, courts typically inquire whether the defendant's actions were felt, whether or not the actions themselves occurred within the forum. That's citing Yahoo versus League Against Racism, which itself cites Calder versus Jones, Supreme Court, 1984. See also AMA Multimedia versus Wannett, 9th Circuit, 2020, which says, where allegedly tortious conduct takes place outside the forum and has effects inside the forum, our circuit has examined purposeful direction using an effects test. Under the effects test, a defendant purposely directed her activities at the forum if she, 1, committed an intentional act. The videos are an intentional act. 2, expressly aimed at the forum state. 3, causing harm that the defendant knows is likely to be suffered in the forum state. That's citing Morrill versus Scott Financial Corp, 9th Circuit, 2017. See also Panavision International versus Tapin, 9th Circuit, 1998, which says it is not required that a defendant be physically present or have physical contacts with the forum, so long as his efforts are purposefully directed toward forum residents. Plaintiff's allegations, along with defendant's own allegations, meet the effects test. First, defendant admits that she intentionally posted over 100 TikTok videos stating that plaintiff had a relationship with a student and then ordered the murder of 4 students to conceal that relationship from the public. Second, these videos specifically accused plaintiff, a University of Idaho professor and resident of Idaho, of having an affair in Idaho with a University of Idaho student and then killing that student and 3 other University of Idaho students in Idaho. And that's quoting Morrill again. See also Mencken versus EMM, Ninth Circuit 2007, which says the requirement is satisfied when the defendant is alleged to have engaged in wrongful conduct targeted at a plaintiff whom the defendant knows to be a resident of the forum state. Third, taking plaintiff's allegations as true, defendant undoubtedly knew that, given that the accusations regarded alleged conduct by plaintiff in Idaho and that plaintiff resides and works in Idaho, any resultant harm would also take place in Idaho. See also Brayton Purcell, LLP versus Recordon and Recordon. Ninth Circuit 2010, which says this element is satisfied when defendant's intentional act has foreseeable effects in the forum. Because the effects test is met, so too is the purposeful direction requirement for specific jurisdiction. Plaintiff has therefore met her burden as to the first prong of the personal jurisdiction analysis. The next prong, arise out of or relate to forum activities. Under the second requirement for specific jurisdiction, the plaintiff's claims must arise out of or relate to the defendant's forum-related activities. The Ninth Circuit follows the but-for test. What's a but-for test? Pooping. But it follows the but-for test to make this assessment. That's from Mencken. Hence, plaintiff must show that she would not have suffered an injury but for defendant's forum-related conduct. Plaintiff's and that's not just saying, but for the plaintiff being shitty. Because, but for pooping. Plaintiff's allegations easily meet this standard. Plaintiff alleges that defendant's TikTok videos harmed her reputation and caused physical injury. Assuming plaintiff's allegations are true, which we must here, plaintiff would not have suffered an injury but for defendant's forum-related conduct. Plaintiff's defamation claims against defendant clearly arise out of and relate to defendant's TikTok videos, conduct that was directed at plaintiff in Idaho, relating to matters taking place only in Idaho. Plaintiff has therefore met her burden as to the second prong of the personal jurisdiction analysis. So now the burden has shifted for Ashley Guillard to show unreasonableness. So once the plaintiff establishes the first 2 requirements for specific jurisdiction, the forum's exercise of jurisdiction is presumed reasonable unless the defendant presents a compelling case that the exercise of jurisdiction would, in fact, be unreasonable. That's citing Shute versus Carnival Cruise Lines, Ninth Circuit, 1990, which itself quotes Burger King. This is the third and final requirement for specific jurisdiction. To evaluate reasonableness, courts within the Ninth Circuit weigh 1. The extent of the defendant's purposeful interjection into the forum state's affairs. 2. The burden on the defendant of defending in the forum. 3. The extent of conflict with the sovereignty of the defendant's state. 4. The forum state's interest in adjudicating the dispute. 5. the most efficient judicial resolution of the controversy. 6. The importance of the forum to the plaintiff's interest in convenient and effective relief. And 7. The existence of an alternative forum. Those factors come from Freestream Aircraft versus Aero Law Group, 9th Circuit, 2018. A court must balance all 7 factors, as no single factor is dispositive. That's Rio Props Inc. versus Rio International Interlink, 9th Circuit, 2002. Defendant has not seriously attempted to meet this high burden, other than to mention in passing that she is from Texas and published her TikTok videos from Texas. But that is not enough to render jurisdiction in Idaho ipso facto unreasonable. To the contrary, it is reasonable for this court to exercise jurisdiction over a defendant in this instance. As shown above, plaintiff sufficiently alleges that defendant purposely injected herself into Idaho-specific matters through her repeated TikTok videos. And while defendant no doubt will be burdened to some extent with having to defend herself in Idaho, she has done so to this point without any obvious hassle or impediment. I mean, especially she hasn't even had to go to Idaho. She's to the extent that court hearings have occurred, she's been able to do them telephonically or at least electronically. I don't know if she dialed in on phone or if it was like Zoom, a video participation, but either way, back in the day, she might have had to show up in Idaho. That's quite a burden. But where she just has to phone in, and she doesn't have to go to the courthouse to file. She can file with ECF. Hey, the internet's everywhere. Where's the burden? And I mean, in this day and age, it's not even long distance calls. When you use a cell phone, long distance isn't a thing, at least within the country. So it's not an added expense to phone in. It would be just as expensive to phone into the Houston federal court. So and as to that point, C.E.G. Sinatra versus National Enquirer, 9th Circuit, 1988, which says modern advances in communications and transportation have significantly reduced the burden of litigating in another forum. And that's from all the way back in 1988. Here, towards the end of 2023, we have 35 more years of technological advancements rendering the burden negligible. I mean, unless it goes to trial, which I'm going to tell you a secret. Lawyers, like here in Utah, I mean, I live close enough to the federal court that if I'm litigating in federal court, I just stay at home and I travel, make the commute. But like, if I'm living in Provo, and that's just Provo, that's 40 miles away. If I'm litigating a case in the federal court, downtown Salt Lake, if I have a week-long trial, guess what? I'm staying in a hotel right next to the federal courthouse in downtown Salt Lake. Why? Because I don't want the hassle. And people do that with state court as well. I mean, federal courts are really limited. There's only so many within a state, whereas state courts, every county has at least one. if I'm litigating in state court, if I've got a big trial and it's not in Salt Lake County, there's a good chance I'm staying in a hotel. I mean, even look back at the Gwyneth Paltrow trial here in Utah. That was in state court, 3rd District Court, Silver Summit, Park City. That's in good weather, a 25-minute drive from my house. I tried to get up there to watch Gwyneth Paltrow testify, but there was a snowstorm. I turned around at the first exit in the Parley's Canyon because it was too treacherous. Those of you on the East Coast are, a little snowstorm. Parley's Canyon is scary in the snow. But all of the lawyers practiced downtown Salt Lake. I guarantee they were all staying in hotels that whole trial. They were in hotels up in Park City because you don't want the hassle. But for litigation, for motions practice until trial, you at the moment you can pretty much do that from anywhere as long as you've got a good internet connection. So yeah, modern advances indeed. There is also no reason to believe that Texas has a particular interest in this case. So that would be a sovereignty issue for Texas, in an interest in protecting Texas's sovereignty for Texas. In comparison, given Idaho's law's application to plaintiff's defamation claims, Idaho has a strong interest in adjudicating the parties' dispute. Next, there are likely just as many witnesses, if not more, in Idaho as there are in Texas, making Idaho the most efficient and convenient forum for plaintiff. Finally, the existence of an alternative forum in Texas is not enough to counter the cumulative weight of the remaining factors. Weighing all 7 factors together, it is reasonable for this court to exercise specific jurisdiction over plaintiff. In sum, plaintiff has made a prima facie showing of jurisdictional facts, and all 3 requirements for specific jurisdiction have been satisfied. Thus, the court's exercise of personal jurisdiction over defendant comports with federal constitutional principles of due process, and the court has personal jurisdiction in this matter. Defendant's motion is denied in this respect. Next up, venue is proper in this district. Generally, venue is proper and an action may be brought in 1. The district in which any defendant resides. 2. A district in which a substantial part of the events or omissions giving rise to the claim occurred. Or 3. If neither is available, then any district in which a defendant is subject to personal jurisdiction. That's citing 28 U.S.C. section 1391 B 1 through 3. And that's the venue statute. Plaintiff alleges that venue is proper in this district under section 1391 B2 because a substantial part of the events giving rise to the claims occurred in Idaho. Defendant disagrees. Defendant argues that since plaintiff claims to not have killed the students, the only event that gave rise to the civil action is the alleged defamation that occurred on social media, published mostly in Texas and accessed in several states. She instead submits that proper venue, assuming subject matter jurisdiction, is in the federal district court for the Southern District of Texas, and that under 28 U.S.C. section 1406A, the action should either be dismissed outright or transferred there. And footnote 5, defendant additionally claims that the court's August 8, 2023 memorandum decision and order is void, presumably invoking Rule 60B4 once again. Notably, defendant does not formally move to dismiss plaintiff's claims under Rule 12b3 for improper venue. Defendant's argument fails. The Ninth Circuit has ruled that when determining where a substantial part of the events or omissions giving rise to the claim occurred in a tort action, the locus of the injury is a relevant factor. That's citing Rogers versus Color Street, District of Idaho, 2023, quoting Myers versus Bennett Law Offices, Ninth Circuit, 2001. Here, owing to defendant's alleged defamatory statements, plaintiff claims to have suffered damage to her reputation, career, and mental health, all occurring in Idaho. Because there is no basis to conclude that the alleged defamation was felt anywhere other than Idaho, venue is likewise proper in Idaho and in this district. That's citing Rogers, which says, thus, the court assumed Rogers felt the harm of the allegedly defamatory statements in Idaho, where she was residing when the statements were made in 2022. This would mean that a substantial part of the acts, events, or omissions that gave rise to the defamation claim occurred in Idaho, and venue in Idaho is appropriate with respect to these claims pursuant to 28 U.S.C. Section 1391b2. So, hey, they've even got case law saying, hey, the venue where the effects of defamation are felt is a proper venue. So that venue may also exist elsewhere, does not undo this reality. Defendant's motion is denied in this respect. So basically, that last sentence before the denial, it meant, hey, just because Texas might also be an appropriate venue doesn't mean Idaho isn't too. There venue analysis, that there can be more than one appropriate venue. And guess who gets to pick that venue if there is more than one? The plaintiff. The plaintiff is the master of their case. So, next up, defendant's disagreement with the court's August 8th, 2023 memorandum decision and order, without more, neither renders it void nor establishes a lack of judicial impartiality. This section should be fun. The court's August 8th, 2023 memorandum decision and order dismissed defendant's counterclaims against plaintiff and quashed the summonses for plaintiff's counsel. Defendant disagrees with the order and claims that it is void, this time under Rule 60b-6, not Rule 60b-4, because it is obviously biased, one-sided, lacks in impartiality, and likely maliciously motivated. She lodges the following objections to support her claim. 1. The court violated her First Amendment rights by ruling on the plausibility of her tarot card reading and psychic abilities. 2. The court contradicted itself and surpassed its authority when weighing in on the plausibility of plaintiff's claims. 3. The court improperly left open the possibility of future sanctions. And 4. The court improperly gauged the parties' interest in settlement negotiations. Defendant's argument is without merit. Defendant's disagreement with the court's analysis is not a basis for reconsideration. That's citing Hannigan versus OPSEC, District of Idaho, 2023, which says a party seeking reconsideration must show more than a disagreement with the court's decision and recapitulation of the cases and arguments considered by the court before rendering its original decision fails to carry the moving party's burden. See also Johnson versus Kijakazi, Southern District of California, 2023. And that's persuasive authority, but it is a district court within the Ninth Circuit, so it's a whole lot more persuasive than when Ashley Guillard was citing, the Texas Court of Criminal Appeals, which was barely persuasive at all. But, I mean, and here, the court is basically adopting it, saying, yeah, we find this persuasive, and we're the court, so it is persuasive. And now it might even be binding in Idaho. A motion for reconsideration cannot be granted merely because a party is unhappy with the judgment, frustrated by the court's application of the facts to binding precedent, or because he disagrees with the ultimate decision. Moreover, the court's analysis and defendant's disagreement relating thereto do not support a finding of bias or partiality. Mogan versus Sachs, Ricketts, and Case, Ninth Circuit 2023, which says any alleged claim of bias must stem from an extrajudicial source, and almost all of Mogan's arguments as to any potential bias arise from his disagreement with the judge's decisions. That was quoting Lightkey versus United States, Supreme Court, 1994. In sum, defendants' disagreement with the court's adverse rulings may represent a basis for appeal. They do not, however, justify voiding those rulings or establish any bias whatsoever. Defendant's motion is denied in this respect. And you remember me about an hour ago saying that 60B4 or either B4 or B6, it was an hour ago. It was abuse of discretion, and you'd have to appeal it. That's what the court says. Hey, if you think I'm wrong, appeal it. But that's for the appeals court to decide. It's not for a 60B motion. That's ridiculous. But don't appeal. That'll just be a waste of money. Frankly, it'll be a waste of $505, I think. I think that's the filing fee. Next, the court did not improperly judge defendant's religious beliefs. Defendant responded to plaintiff's defamation claims by going on the offensive, alleging that those claims, as well as statements made by plaintiff's counsel to the media about those claims, were themselves defamatory and purposely brought by plaintiff and her counsel to systematically deprive defendant of her constitutional rights to free speech and due process. Certain of defendant's counterclaims reflected these beliefs: first, second, third, fourth, fifth, eighth, and ninth counterclaims, alongside related counterclaims for malicious prosecution and intentional infliction of emotional distress, 6th, 7th, 10th, and 11th counterclaims. Together, these counterclaims presumed and depended upon an alternate version of events surrounding the murder of the 4 University of Idaho students, namely that plaintiff orchestrated the murders and then colluded with her counsel to bring this action against defendant to silence her clairvoyant insight into the true extent of plaintiff's involvement. The court's August 8, 2023 memorandum decision and order dismissed defendant's counterclaims because there was no objective basis to believe that plaintiff did the things that defendant publicly and repeatedly claims she did. Defendant's intuitive abilities, spiritual acuity, and investigative skills were not enough to allow the court to infer the existence of a plausible claim against plaintiff. Because the predicate components of defendant's counterclaims against plaintiff lack any basis in fact, those counterclaims should not proceed. At bottom, the court struggles to accept defendant's allegations as creating factually plausible counterclaims against plaintiff. Defendant takes issue with the court's analysis. She argues that because the court does not have subject matter jurisdiction over the plausibility of spiritual practices, its August 8th, 2023 memorandum decision and order is void. And that motion says, her Guillard's motion, she says, the court intentionally erred in denouncing tarot readings and defendant's spiritual connection as a spiritual practice for the purpose of overstepping the separation of the church and state as required by federal laws and the First Amendment of the United States Constitution. But the court says defendant's argument cannot succeed. To survive a motion to dismiss, a complaint must contain sufficient facts accepted as true that state a claim to relief that is plausible on its face. Twombly, once again, imagine that. A claim is facially plausible when a plaintiff pleads sufficient facts to allow the court to reasonably infer that the defendant is liable for the misconduct alleged. Though courts generally construe pro se party filings liberally, a court may dismiss as frivolous claims that are clearly baseless, a category encompassing allegations that are fanciful, fantastic, and delusional. That's citing Denton versus Hernandez, Supreme Court, 1992, which says, as those words suggest, a finding of factual frivolousness is appropriate when the facts alleged rise to the level of the irrational or the wholly incredible. See also Knightsky versus Williams, Supreme Court, 1989. The term frivolous, when applied to a complaint, embraces not only the inarguable legal conclusion, but also the fanciful factual allegation. In this context, claims that are clearly baseless are not facially plausible. Here, defendant's counterclaims were supported only by her spiritual intuition. But intuition, even if summoned by one's spirituality, does not make a legal claim plausible. Otherwise, there would be no standard against which such claims can be tested under Rule 12b-6, and asserted First Amendment protections would automatically insulate affirmative claims from dismissal, while conversely protecting actionable conduct as well. This is not the standard, nor can it be. So, exactly. If all you have to do is say, but Your Honor, my intuition says, then what's to stop anyone from using that as a defense or an offense? If you don't have anything but your intuition, all you're doing is making conclusory statements. You need evidence. Evidence. And CEG Counterman versus Colorado, Supreme Court 2023, which said First Amendment the First Amendment permits restrictions on false statements of fact harming another's reputation. False and defamatory statements of fact, we have held, have no constitutional value. At bottom, claims must be based in fact, not conclusory, and unverifiable beliefs. With this standard in mind, the court simply held that, absent objectively verifiable factual allegations, defendants' counterclaims were implausible. Nothing more, nothing less. But the court did not stop there. It went on to explain how each of defendants' counterclaims against plaintiff is also legally deficient. So they're not only factually deficient, they're also legally deficient. In other words, Defendants' counterclaims were not dismissed only because they were deemed implausible. Each counterclaim distinctly failed as a matter of law. And if you heard a noise before I read that statement, it wasn't a fart. It was my rubber foot rubbing against the metal on the chair. The joys of having a rubber foot. Of course, if I step in a puddle, it's rubber foot. Doesn't matter. These merits-based shortcomings separately undercut defendants' argument that the court's August 8, 2023 memorandum decision and order is void for impermissibly commenting on the plausibility of defendants' spiritual practices. Defendant's motion is denied in this respect. Next up, plaintiff has stated a claim for defamation. Defendant lastly argues that plaintiff's defamation claims against her should be dismissed because 1. Idaho's judicial privilege covers the statements made in her TikTok videos, and 2. Plaintiff has not adequately stated a claim for relief. Defendant's argument is meritless. First, Idaho's judicial privilege immunizes a party from civil liability for statements made in the course of judicial proceedings. See Berrien versus Berberian, Idaho Supreme Court 2020, which says Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. The purpose of the judicial privilege is to keep the paths leading to ascertainment of truth as free and unobstructed as possible. And we discussed Berrien versus Berberian, or at least the quotations to it, in depth, and how it's absolutely ridiculous to claim, well, I'm a party to the criminal litigation because, I phoned the FBI tip line. So my TikToks were privileged. This privilege sets a low bar, only requiring that the defamatory statement, 1, be made in the course of a proceeding, and 2, have a reasonable relation to the cause of action of that proceeding. That's citing Dickinson Frozen Foods versus J.R. Simplot, Idaho Supreme Court 2019. That was also quoted in the motions. Defendants' TikTok videos do not satisfy this standard. To be clear, a judicial proceeding in this context is not limited to trials, but includes every proceeding of a judicial nature before a court or official clothed with judicial or quasi-judicial power. That's citing Malman versus Engler, Idaho Court of Appeals, 1993, which self-quotes Richardson versus Kessler, Idaho Supreme Court, 1953. So it's not just at trial where the litigation privilege exists. It exists in the pleadings, in the complaint, in the motions, in the court hearings. So defendants' TikTok videos, on the other hand, were never made in any proceeding that can be understood as judicial in nature. And while statements made to law enforcement may be subject to a qualified privilege, Berrien, defendants' TikTok videos existed independent of any criminal investigation into the murder of the 4 University of Idaho students. That is, the allegedly defamatory statements embedded within defendants' TikTok videos were not relayed just to law enforcement as part of a discrete criminal investigation into the murders. Instead, they were effectively disseminated worldwide. That statements may also emphasis, it's in italics, emphasis. That statements may also have been communicated to law enforcement does not then immunize them, particularly when no charges have ever been brought against plaintiff. Second, defendant's insistence that plaintiff has not proven her defamation claim misunderstands plaintiff's burden at this phase of the proceedings. At the motion to dismiss stage, plaintiff need not prove anything. She needs only to allege facts that, if true, plausibly support a claim. And that's Twombly. Plaintiff has done this. She has alleged that defendant made false and defamatory statements implicating plaintiff in a relationship with a student and the murder of 4 students, that defendant knew her statements were false, and that plaintiff was damaged as a result. These allegations support a defamation claim under Idaho law. That's citing Clark versus the Spokesman Review, Idaho Supreme Court 2007. See also IDJI 4.82. A motion to dismiss is not the proper legal mechanism for substantively challenging those allegations. That is the function of either a motion for summary judgment or, eventually, trial. Until then, defendant's motion is denied in this respect. Order. Based on the foregoing, it is hereby ordered that defendant Ashley Guillard's motion to set aside and motion to dismiss is denied. Dated November 13th, 2023 by Raymond E. Patrico, Chief U.S. Magistrate Judge. And we have footnote 6, which plaintiff again requests that the court exercise its inherent power and award attorney's fees to plaintiff. For reasons already articulated in previous orders, the court declines to sanction defendant at this time. And at this point, I understand the judge's reasoning, but I disagree with it, especially hard on this one, because this motion to dismiss, it was completely frivolous because it was untimely. So it was completely unnecessary litigation because it was already decided. So he needs to start sending a message that, hey, you've got to litigate in good faith, otherwise it's going to cost you money. Now, he did say at this time. That doesn't mean, Professor Scofield might get all of her attorney's fees at the end. I think at least for the purposes of the litigation of this motion, she should have been granted them. That's my opinion, but I'm not a judge. I'm not even a magistrate. I'm not even in Idaho. But either way, I frankly, at this point, I expect Professor Scofield to get at least some attorney's fees at the end. I could be wrong, but it's what I'm expecting. So next up, going back on the docket, but not back in time because they're both filed the same day. But we are switching from Ashley Guillard's motion to dismiss and motion to reconsider over to Professor Scofield's motion for partial summary judgment. This is the reply in support of plaintiff's motion for partial summary judgment. And it's considerably shorter than the decision we just read, being only 7 pages total. So, introduction. In her opening brief, Professor Scofield established the facts necessary to prove that Ms. Guillard defamed Professor Scofield when Ms. Guillard stated that Professor Scofield had an affair with a student and then orchestrated 4 horrific murders. Remember, the standard in summary judgment is basically no disputed material facts taken in the light most favorable to the non-moving party, and blah, blah, blah. So Professor Scofield's asking the court to grant her the win, and then the only thing left to decide at trial will be the amount of damages. So, in her opposition, Ms. Guillard did not submit a single fact to support the validity of her false statements or to dispute the facts presented by Professor Scofield. She instead seeks to excuse her failure to respond to discovery and asserts that her false statements fall under the judicial privilege. Both arguments fail. I mean, the court's already ruled, today even, on the judicial privilege. Both arguments fail. Ms. Guillard consented to electronic service, which is how Professor Scofield served her discovery. And the judicial privilege does not apply to statements made on TikTok. This case has been pending for nearly a year. It is time to end Ms. Guillard's baseless assertions and to begin to repair Professor Scofield's reputation. Professor Scofield requests that the court enter judgment in her favor as to Ms. Guillard's liability and set this matter for a jury trial to determine Professor Scofield's award of damages. So you may remember in my previous video, I think discussing Ashley Guillard's opposition to summary judgment, I remember making a guarantee of what would show up here. I don't remember exactly what the guarantee was about, but I think it was as to Guillard saying, well, I never got the discovery request. And I think the guarantee was, we're going to see the exact email that the discovery request came in, supported by a sworn affidavit by Wendy Olson saying, yep, this is the email. So bear that in mind. Argument. Professor Scofield served the requests for admission on Ms. Guillard. Ms. Guillard does not dispute that she failed to respond to Professor Scofield's requests for admission. She excuses her failure by saying she was not served. Like her statements about Professor Scofield, Ms. Guillard's excuse is false. On June 20th, 2023, Professor Scofield served her first set of interrogatories, requests for production of documents, and requests for admission to defendant on Ms. Guillard using the email address. And it's the email address Ms. Guillard listed on all her filings and her CM-ECF registration. This is sworn to in the second declaration of Wendy J. Olson in support of plaintiff's motion for partial summary judgment and Exhibit A. So we have the declaration, but I have it scrolled down here. This is Exhibit A. I have it scrolled down because I'm trying not to highlight Ashley Guillard's email address, but I mean, you can go to the docket if you want and look to make sure I'm telling the truth, but this is sent to the email address that is associated with her ECF account. And subject, you can barely see it at the top, but Rebecca Scofield versus Ashley Guillard, and the case number and the attachments, plaintiff's first set of interrogatories, requests for production of documents. Ms. Guillard, attached are plaintiff's first set of interrogatories, requests for production of documents, and requests for admission to defendant. Thank you, sent by Tracy Horan, practice assistant, Stoll Reeves. Told you that email would be an attachment. So, Professor Scofield properly served her discovery requests via email. Ms. Guillard asked the court to let her use CM-ECF, and the court granted her request on the condition that she must follow all applicable procedures for electronic case filing, including but not limited to the District of Idaho's local civil rules and electronic case filing procedures. The latter states that registration to use the e-filing system constitutes consent to electronic service. And that's citing United States District and Bankruptcy Court, District of Idaho, Electronic Case Filing Procedures, Section 3.A3, stating that registering to use the court's e-filing system constitutes consent to electronic service. As a result, Professor Scofield properly served her discovery requests on Ms. Guillard when Professor Scofield sent them to the email address that Ms. Guillard provided to the court. Federal Rule of Civil Procedure 5B2E, which states that a paper is served when it is sent by electronic means to a person that consented to electronic service, which Guillard has done by requesting ECF access. Any argument to the contrary is disingenuous. But, Your Honor, I wasn't even in Texas. I was in New York on June 20th. And my email only goes to Texas. Ms. Guillard herself has used email to serve a notice of intent to serve subpoena, her initial disclosures, and a request to waive service. That's Exhibits B, C, and D. So, Exhibit B, sent to the attorneys, notice of intent to serve subpoena on Facebook. And it's from, once again, I've scrolled down so you can't see Ashley Guillard's email address on this, but it is the same email address that the request for admissions were sent to. And greetings, attached is a notice of intent to serve subpoena on Meta Platforms, Inc., also known as Facebook. Thank you, Ashley Guillard. And then defendant's initial disclosures. Greetings, attached is defendant Ashley Guillard's initial disclosures. Ashley Guillard. And finally, we have waiver of service request countercomplaint for the case. So this is basically asking the attorneys to waive service to become counter defendants. So why did we have those ones attached as exhibits? We're not arguing about those. We're not arguing the Facebook subpoena here. But what this amounts to is a clean hands argument. It's saying, look, Ashley Guillard is serving us by email. She's emailing her discovery requests to us. She's emailing her subpoenas to us. She's emailing her request to waive service to us. But when we email ours to her, she says, well, I didn't see it, therefore I'm excused. But it doesn't work that way because, number one, she consented to electronic service. But number two, she is taking part in electronic service. So it works both ways. So Ms. Guillard's failure to respond to Professor Scofield's request for admission establishes the facts needed to grant summary judgment for Professor Scofield. Ms. Guillard does not dispute that she failed to timely respond to Professor Scofield's discovery requests. In fact, Ms. Guillard has not responded to Professor Scofield's discovery requests at all, even after Professor Scofield filed this motion. Ms. Guillard's failure to timely respond to Professor Scofield's request for admission constitutes an admission to each such request, citing Federal Rule of Civil Procedure 36A3. And a matter admitted under Federal Rule of Civil Procedure 56 is conclusively established. It is thus established that Ms. Guillard stated publicly that Professor Scofield was involved with the murders of the students. Professor Scofield was not involved with the murders of the students. The only basis for Ms. Guillard's public statements that Professor Scofield participated in the murders is Ms. Guillard's spiritual research, intuition, and instincts. Ms. Guillard is unaware of any physical evidence linking Professor Scofield to the murders. Ms. Guillard has no written information and has not received any information orally from another human being showing that Professor Scofield ever met the students. Ms. Guillard knew that the Moscow Police Department issued a press release on December 7th, 2022, stating that it did not believe that the female associate professor and chair of the history department who is suing a TikTok user for defamation is involved in this crime. Ms. Guillard publicly stated that Professor Scofield had an affair with a student. Professor Scofield did not have an affair with a student. The only basis for Ms. Guillard's statement that Professor Scofield had an affair with the student was Ms. Guillard's spiritual research, intuition, and instincts. Ms. Guillard is unaware of any physical evidence that Professor Scofield had an affair with the student. Ms. Guillard has offered no admissible evidence to raise any dispute, let alone a genuine dispute about these facts. Even if Ms. Guillard could produce any evidence to the contrary, she cannot. Such evidence is inadmissible to contradict her admissions. That's citing 999 versus CIT Corp., 9th Circuit, 1985, which says, evidence inconsistent with a Rule 36 admission is properly excluded. Federal Rule of Civil Procedure 36B Advisory Committee note to the 1970 amendment, which says, in form and substance, a Rule 36 admission is comparable to an admission in pleadings or a stipulation drafted by counsel for use at trial, rather than to an evidentiary admission of a party. And GTE Directories Corp. Versus McCartney, 9th Circuit, 2001, unpublished, which says, introduction of allegedly contradictory evidence cannot serve as an implied motion to withdraw admissions. Simply put, there is no genuine dispute that Ms. Guillard falsely stated that, 1, Professor Scofield had an inappropriate sexual relationship with a student, and 2, Professor Scofield orchestrated the murders of the students. Those statements are defamatory per se because they, 1, impute to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. That's citing Serkey versus Serkey, Idaho Supreme Court, 2020. And 2, ascribe to Professor Scofield conduct incompatible with the proper conduct of Professor Scofield's lawful business, trade, or profession. That's citing Barlow versus International Harvester, Idaho Supreme Court, 1974. And 3, impute serious sexual misconduct to Professor Scofield. That's citing Yoakum versus Hartford Fire Insurance Company, Idaho Supreme Court, 1996. Because Ms. Guillard's false statements were defamatory per se, she need not prove special damages. That's citing Serkey. Ms. Guillard does not appear to argue otherwise, nor can she. Professor Scofield is thus entitled to summary judgment in her favor on liability. Next, the judicial privilege does not apply. Ms. Guillard argues the judicial privilege protects her from liability for her false statements about Professor Scofield because the murders were under investigation at the time Ms. Guillard defamed Professor Scofield. This, too, is incorrect. Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. That's Berrien versus Berberian. The term judicial proceeding is not restricted to trials, but includes every proceeding of a judicial nature before a court or official clothed with judicial or quasi-judicial power. Wow! Those are the exact same quotations as from the judicial opinion we read to start this video. Imagine that. Accordingly, defamatory statements made by private individuals to law enforcement officials prior to the institution of criminal charges are entitled to a qualified privilege, not an absolute privilege, and this qualified privilege will not apply when the defamatory statements are made with malice. Ms. Guillard's defamatory statements were not made during a trial or other similar judicial proceeding. They were made on TikTok. And Ms. Guillard's defamatory statements were not made to law enforcement officials prior to the institution of criminal charges. They were made on TikTok. Accordingly, because Ms. Guillard's defamatory statements were not made in a judicial proceeding of any kind, the judicial privilege does not apply. And there is no privilege for TikTok. Conclusion. Professor Scofield requests that the court grant her motion for partial summary judgment. Dated November 13th, 2023. Signed, Wendy J. Olson. So, I'm a little disappointed that they didn't bring up the Marine. Well, was he a Marine? The member of the armed forces that killed himself, that prove that Ashley Guillard is psychic, that she's clairvoyant, that she's not a charlatan. I would have liked to see mention of that, but it doesn't matter anyways, because she's already admitted that she has no evidence. So that's all that's really required. But either way, where do we go from here? I expect, as I said at the beginning, unlike the motion to dismiss that we got the answer today, I expect there to be oral arguments on this. I don't think they need oral arguments, but I think the court will grant oral arguments just to give that veneer to Ashley Guillard that, hey, we've given you every opportunity to state your case. Every opportunity. We had enough based on the writings, based on the motions, to grant partial summary judgment. But we're going to listen to you even though we really don't have to. And then we'll get a decision. Like I said, this was put in on the 1-year anniversary of the murders. Will we have a decision by the 1-year anniversary of the beginning of the defamation? No. By the 1-year anniversary of the lawsuit? Probably not. Early next year? Probably. So, and then we'll see when trial happens. It's like I've said, I think we're near the very end of the road as to liability, but we're going to have a long way to go in determining how much liability. So with that, like I mentioned in yesterday's video, reacting to the pro se idiot in Bay County, I'm going to fairly soon start doing finance videos. Think Dave Ramsey without the politics and religion, Susie Orman, in addition to other finance videos, but like doing personal financial analysis for people, have them give me an open look at their finances and discuss it, analyze it. So if you're willing to be tribute, one of the first volunteers, email me and let's start getting it set up and you know, hopefully if you participate, you'll get value out of it. Because, you know, like I said, degrees in finance, I'm kind of smart at it. So either way, gonna leave it there. Thanks for joining me. Do all the YouTube-y stuff. Like, share, subscribe, bribe your friends to do the same. And I will see you very soon for the next one. Thanks for joining me. Bye-bye.